lot of the funders I know have been trying to get their heads around potential sort of crypto claims, and you can sort of have these exchanges or players in that space exist one day and not exist the day after. And so thinking very carefully through how you trace assets or put a hold on them while a piece of litigation or arbitration is ongoing is something that everyone's paying a lot of attention to.
Cathro and Partners presents The Cut, a podcast about all things insolvency.
Well, hello everyone, this is the next episode of The Cut. My name's Simon Cathro, I'm the Managing Partner at Cathro and Partners, and today we have a great guest, Matt Lee from Lindsay Francis Mengen, to talk about litigation funding and arbitration. Matt, how are you?
G'day, Simon. Thanks for having me.
That's good. Tell me a bit about yourself first.
So I have been out in Australia prior to my role at LFM, running the world's largest, the Australian operations of the world's largest litigation funder. And as part of that role, increasingly sort of being a consumer of legal services from the top tier law firms across Australia, thought given how expensive legal fees are sort of pretty across the board, perhaps a good business opportunity would be to start a firm that tried to do something in a bit more cost-effective way.
So that was Lindsay Francis Mengen. So tell me a bit about that firm.
Yeah, so it's a specialist dispute resolution firm that focuses solely on arbitration and litigation across the Asia-Pacific region. The original part of the firm grew out of Auckland, New Zealand. So we've got two partners out there, Tim Lindsay and Kim Francis. And we've got, as of last year, an Aussie, Mark Mangan, up in Singapore, who's running a pure arbitration shop in that neck of the woods.
Yeah, great guy, apparently. So,
yeah.
I went to school with him. So, look, today we wanted to focus on arbitration and litigation funding. We might start with the litigation funding. Most of our viewers are from the insolvency and restructuring space, or people that support that industry through getting us involved in helping their clients. So litigation funding is something that's quite active in our market, but just give us a bit of an overview first as to what actually is it.
Basically, at a high level, legal finance or litigation funding is where a finance institution will provide the funding for a claim, whether that's litigation or arbitration, and that pays for the legal fees, disbursements, and oftentimes the adverse cost exposure associated with litigation or arbitration. That's particularly relevant in jurisdictions like Australia, where you can be slugged with adverse costs if you lose. And in return for paying those fees and disbursements and adverse cost exposure, the funder will take a piece of the upside of any case, and they call it sort of a non-recourse form of financing, because if the result goes the other way, the funder wears that risk. Yeah,
and what are the type of areas that litigation funding gets involved with?
Well, it's pretty interesting and a good question, because in Australia, when you speak with most people about it, they either, if they're from an insolvency background, they're pretty familiar with it. The other space in Australia is often class actions. Yeah. So classic case of you've got a group of folk who may individually have, in relative terms, small claims, but they need to sort of aggregate those claims together and bring them as part of a group. And funding historically has grown out of the use of finance for that purpose, to fund group members bringing large class actions, which typically can be in the tens of millions of dollars worth of legal fees. And so obviously the plaintiffs in those cases can't fund that case themselves. And so that historically is how it's been borne out in Australia. By contrast, in jurisdictions like America, where you've got contingency fees, a lot of the law firms will do that work funding that themselves on a contingency fee basis. That's not, with some limited exceptions down in Victoria, Australia, allowed in Australia. But more recently, what you'll see is that there's an increasing sort of appetite on behalf of corporates to say this isn't just an insolvency or class action related product, but if we have to chase down large commercial claims and pay the top end of town law firms and barristers to be able to unlock the value in those claims, the C-suite and the in-house counsel at those companies are increasingly considering whether the use of legal finance can help both get de-risk the costs and risks of those pieces of large commercial litigation, and also sort of get some certainty about timing as well.
Yeah, and I think family law in certain jurisdictions have had litigation funding in there as well, isn't it?
That's right, and you see that in some jurisdictions, but not others. And just to use APAC as a good example, you can't do that up in Hong Kong and Singapore, but there is forms of that allowed in Australia.
Right, and look, speaking personally, I've used a lot of litigation funders in matters where I'm a liquidator of, and primarily I have no assets or am unfunded, and there's a little bit of risk that maybe I might not win. So for me, it's like I contemplate the funding where it's where I have that situation. The other funder or main funder in our space is the Attorney General, the federal government, and they seem to have the most competitive rates in our space because they limit their premium to what their debt is and the amount that they've paid out to employee entitlements as a result of the company going into liquidation. And so once you sort of get into the actual funding of the actual matter, what's the role that the litigation funder plays?
Yeah, so the obvious answer at first instance is just providing the capital to be able to pay all the different folk who will work on a case from its inception all the way through to, if necessary, going through to the end of a trial or arbitration, and then through to either an appeal or an enforcement campaign if you've got to run around and chase an award debtor elsewhere. But then I think a bit that's often overlooked is the sort of case management function that's provided by the litigation funders, because really they're professional litigants. And so they see, much like insurance companies, way more reps than your typical company would, because that's what they live, eat and breathe every day of the week.
Yeah, and they're quite experienced in that area. So they bring to the table a lot of expertise and tactics and techniques to achieve an outcome that is beneficial for obviously the funding party.
Yeah, and look, that was part of the reason to jump back into law firm world was because I'd sort of lived in that world of managing large and complex litigation for over 6 years and seeing just what worked, what didn't work, where expenses can potentially balloon out, where clients are happy to spend money, where they're not, and how to manage budget, time, and resources so that you can maximise the chances of getting a commercial resolution to any dispute.
Yeah. So we go back to the beginning. So you've got a potential claim, whether it's a liquidator, whether it's a class action, whether it's family law or something else. What does the litigation funder want to see to make an assessment in order to determine whether they want to be involved or not, and provide the funding?
Yeah, so they're typically going to look at a handful of different factors. Obviously, they're going to want to form a view on the prospects of success of the case. So that's just looking actually at the specific claims that the law firm or client's legal team has in mind about bringing, and testing the veracity of those claims and what the chances of success are. Some funders perform that function in-house by having legal trained certified folk who live, eat and breathe claims analysis, which was the model the firm I worked at had. By contrast, others have sort of a more outsourced sort of finance model where they will rely on senior counsel in the jurisdiction in which the claim's probably going to be brought to put an estimate on prospects of success. So that's your first criteria. The second is looking just at damages, what commercial recovery is likely from any claim you're going to bring, because in most instances, the funder is going to want to know what money is likely to flow through in the event of a successful recovery.
Yeah.
And then the third one the funders often looking at is recoverability. And I think you'd see this oftentimes in the insolvency space.
Absolutely.
Just because a judge bangs down the gavel and or an arbitrator awards in your favour, that can sometimes only be the start of the adventure, and you can have enforcement proceedings or asset recovery proceedings after a judgment's been or an award's been obtained to try and recover that amount and actually get it paid.
Yeah, and particularly in insolvency, there's no shortage of actual strong claims. There's actually a plethora of all them. There's the real issue is, yes, I can sue that director for insolvent trading, for example. I could sue a party for avoidable transaction. But the reality is what's the financial return? And the main motivation and responsibility for liquidators is to maximise the return to creditors. And, people always say liquidators love cash. Well, that's exactly their job. Their job is to turn things into cash. And what we often find early on in an insolvency appointment is a lot of emotion, a lot of anger, a lot of upset people around certain actions or money being taken out or trading this company and misleading the creditors. But the person that's performing that and breaching those sections of the act often don't have the resources to satisfy any claim. So many times we see situations where people don't get an action taken against them because there's no financial benefit for the actual liquidation. So that's one of the things that we have as liquidators. We don't have any shortage of claims. That in the ideal world and we would be talking to the litigation funder 5 times a day because there's just that many of them, but there just isn't a financial return there that makes sense for the obligation of the liquidator to maximise that return.
Yeah, and the obvious hurdle there in Australia, which I think is often missed when sort of the funding piece gets discussed in sort of popular media, is that we are, and I mentioned this earlier, we're an adverse cost jurisdiction, so you really have to have that front of mind of if we roll the dice on any given case, the funders want to see a return, and so you have to have a high degree of confidence that not only are you going to be able to jump the hurdle of prospects, but there's limited risk of actually a negative result.
And different litigation funders have that different style of assessment, right? So, personally, from my experience, I find that some litigation funders are very detailed in their due diligence, and then others are not so detailed because they've got significant experience in what the actual outcome may look like. Is that sort of your experience in what you've seen in the sense that, or is it just, is the level of in due diligence differ depending on the type of claim?
Look, I was fortunate enough actually in the last role to be out here at a time where there was a real influx of funders into the space, predominantly in the class action space. And so you saw a lot of anecdotal evidence of sort of how everyone in the landscape sort of behaves through to very new players all the way through to your more seasoned investors who've been out here a long time. I think it's correct to note that, the different shops have very different ways of assessing the risk they're taking on. Again, the shop I was at was very heavily not just the actual merits of the legal analysis, but also had quite a robust quantitative function looking at things from a financial point of view as well, modelling that out in terms of timing assumptions, cost assumptions, budget assumptions, just to form a real as best sort of depiction of what they thought was going to happen over the life cycle of a case.
Now, we are going to talk about arbitration, but what I've experienced on litigation funding is, there's a real motivation to mediate. And so thinking back your time where you were that person providing the funding and managing the case through the funder, what did you find was the right time to mediate? Like, again, it's probably different for every case, but what were the sort of things that motivated people to mediate earlier rather than go the full distance and get a judgment?
I think there's a fine balance in that oftentimes there needs to be, for lack of a better term, a bit of sticker shock on both sides of the V for clients to have a more realistic cost-benefit analysis of what the true risks of a case are. That will oftentimes come with some early interlocutory skirmishes being fought out, and or some of the early stage evidence, whether that's lay and or expert evidence being put on the table to understand the case against you better. I've often found that the times that once you're through those processes, usually when there's a more meaningful discussion. Oftentimes, if you try and front run it too early, there can be a real risk of lawyers using the mandatory mediation requirement as a sort of more of a tick box exercise than a robust
genuine effort.
Yeah, genuine effort to bring the case to resolve.
I suppose the stakeholders involved. So you've got the lawyers on both sides of the part, the plaintiff defendants. What's the sort of role that the lawyers will play with each other to try and get potentially two very warring parties to a table to mediate? Is there any sort of effort made between the lawyers to try and just have that commercial discussion early on, just to say, right, okay, we can see each other's arguments and the strengths in each of those arguments? What are the things there that you've seen that have worked quite well?
Well, this is why I say that the case management or the professional litigation sort of insights that a legal financier can provide are very valuable, because I think the answer to your question is it depends on who's driving the bus from the client side. If you've got an insurance company or a litigation finance company that is involved on one side of the V, then they're looking at things through a sort of a very cleared eye or hard-nosed commercial lens, and there's really not as much sort of emotional attachment surrounding any of those decisions. By contrast, if you've got a founder of a company who's sort of emotionally invested in the case, totally aside from the financial side of a case, that can be a barrier to early resolution or any resolution at all. And then likewise, big company with robust in-house legal function that's used to managing pieces of litigation or arbitration will look at things and give instructions to their lawyers in a different way than, say, a medium-sized business that actually only has a piece of adversarial litigation or arbitration once in its life cycle, and so doesn't have the benefit of knowing what a repeat player would do in the consumption of legal services. So I think figuring out who's sort of driving the bus from that point is important, and it oftentimes impacts where you get off ramps in any given case.
Do you think litigation funders look at the person or party that's brought the potential claim for funding and make an assessment as to how are they going to actually behave? Do they look and say, right, okay, I can see the strong claim, yep, tick the box, I've got a legal opinion, or my in-house assessment says there's a real strength here? But I've heard many stories that have been told to me where the funder has provided the funding and then the costs have just blown out because there just wasn't any commercial effort made by the particular legal team or the ultimate client themselves to get to some sort of financial resolution. Do you look at that? Do you think that the funders look at that assessment to start with, just to say, hey, someone walks in the room and they're super emotional and they're wanting to kill the other person and do whatever's necessary to destroy that person? That would lend some weight to say, yeah, I can see a strong claim here, but I can see also that we're going to have to put up with your behaviour to go the full distance, because what you value as more as the strongest value is to get a win, not the actual financial outcome. Do you think that the funders look at that, or was that something that sort of often gets missed?
No, I think all the funders are looking into those factors. You sort of asked me at the outset, what are the funders looking at? I don't think that's quarantined just to the client in any given case. You're really looking at the humans across the spectrum of who's involved, not just from the people at the folk on the client side, but the folk on the opposing side who are likely to be the decision makers. Are they public companies? Are they private companies? But then also the barristers and the law firms you're using on your side and the other side, and then likewise the judge or the arbitrator on any given case. A lot of a lot of detail and time is spent just thinking through what are the likely ways that those humans are going to behave in any given case.
Yeah. Just pivoting a little bit. So then when we look at recoverability, what are the things and criteria that they look at? I mean, if I talk personally, I always feel like litigation funders just, unless there's an insurance policy there, they don't tend to fund. What are the sort of things that they look at to determine that this is worthwhile in pursuing?
Yeah, so you're having a very close look under the hood of the entity or the individuals on the other side that are going to be subject to any potential judgment or award, and asking, do they have the financial ability to wear that?
Yeah. And what are the things once you're in the case? Let's just say there isn't an insurance policy, so there's no D&O or whatever other policy there might be that you can access. What are the kind of things that can be done to ensure that whether that entity or person that you're targeting or pursuing don't dissipate the assets? What are the things that can be done to stop that from happening?
Yeah, so I mentioned sort of preliminary interlocutory skirmishes as part of the sort of the ground that forms the pre-mediation setting. Part of that is often what injunctive relief is going to be sought at the outset of a case to make sure that there's no flight of assets. It's pretty common, and there's a couple of pretty high-profile cases before the federal court at the moment where that sort of urgent injunctive relief has been sought. I mentioned the adverse costs implications of just running a claim in and of itself. Likewise, when you seek that type of injunctive relief, there's undertakings that need to be provided to the court and the other side.
And when you say injunctive relief, does that include like freezing orders?
That's right.
Various things like that to stop people selling assets and often those freezing orders have some sort of flexibility because they allow monies to be released for payment of their legal costs, I suppose, just to enable the actual and to live, I suppose. Sometimes I've seen some pretty broad-based freezing orders. I think it's 1323 of the Corporations Act or something that we're seeing within our space. And it's become popular in recent times to sort of seek those orders to be able to ensure that people are not moving assets offshore or selling assets to the detriment of a potential outcome.
Yeah, look, a great example of that is a lot of the funders I know have been trying to get their heads around potential sort of crypto claims, and you can sort of have these exchanges or players in that space exist one day and not exist the day after, and so thinking very carefully through how you trace assets or put a hold on them while a piece of litigation or arbitration is ongoing is something that everyone's paying a lot of attention to.
Well, let's move into our next topic, arbitration. So I'm pretty interested about this part of the podcast, and that is, tell me what it is.
So arbitration is essentially a private version of dispute resolution where you still have a third party giving a binding resolution to the case, but at least as the theory goes, the parties by their consent under contract have agreed to resolve their dispute confidentiality and via that third party or a panel of arbitrators that agreed upon by the parties, rather than rolling the dice down at your local court, whatever that may be. Obviously in Australia we've got federal courts and state courts that, depending on which day of the week you're reading the paper, sort of commented on how quickly or slowly cases resolve before those courts. But as it was designed, arbitration's meant to be a private sector version where the parties can preserve their confidentiality and have commercial disputes resolved in a way that they, ahead of any dispute arising, meets their business objectives.
So you said in a private sense. So is that a key difference between going to court to arbitration, in the sense that the evidence that gets presented through the arbitration, it stays within the parties that are involved and it doesn't sort of get shared with under public judgments? Or is that sort of the point? Or
that's one of the driving factors. As it was sort of originally formulated, there are cost efficiencies and time efficiencies in creating your own process and having more control over the rules that apply, over who's applying those rules, being the arbitrator or panel of arbitrators. But that confidentiality is usually, if it's not the most important, one of the most important factors in parties choosing to resolve their dispute in that way, rather than going down to court and risking having executives being put in the dock and questioned for days on end in an open court.
So give me an example of one of the of an arbitration that you've seen or witnessed where just from start to go, why they decided to do that, what was the issue at hand or the dispute, and sort of who did they appoint in terms of the arbitrate, how long did it take, and then sort of what was an outcome?
Yeah, so you typically have it's a creature of the contract.
Yeah.
So we mentioned mediation before, often you can have what we call tiered dispute resolution clauses, which will outline the process that the parties will agree to ahead of time, or even after a dispute arises for that matter, that says this is how we would like to resolve it, rather than going down to court and being subject to a taxpayer-funded version of dispute resolution where you have less control over the whole process. Oftentimes, the contract will specify a set of rules that will apply. So, for example, in Australia, you've got the regional body is ACICA, the Australian Centre for International Commercial Arbitration. They have a set of rules that will apply, and parties can choose to have one arbitrator where they'd agree or have the institution appoint one person, or in larger cases, what often happens is each party will choose one arbitrator, and then those two arbitrators will choose the third or the chair to preside over the arbitration, and that's your panel that then decides.
And when in that situation where there's three arbitrators, is there is the chairperson got the casting vote, or how does it work?
Yeah, so that's they're the ones sort of driving the bus on the procedure, but the award itself is much like your High Court or a Court of Appeals. Whoever gets the two rather than the one, or if it's unanimous, I think that the chair is responsible for the internal mechanics of how the arbitration.
And so you talk about appeal, the appeal courts. There's no appeal in arbitration, is there? It's once it's decided, that's it.
That's right. And so over time, culturally, they've tried to minimise the ability to be able to go off and run to different courts or seek any further review, because the whole point of it is to be quicker and more efficient than going before a court and having an intermediate appeal and then potentially up to the High Court in the Australian analogue.
And how long from the time, let's say there is a dispute, and let's say it's in the contract that it sets out that arbitration is the option here. How long does it take? Is it 2 years? Is it 3 years? 5 years? What does it differ?
It can be really varied. And look, the CEO of the company I used to work for and a pretty prominent Australian arbitrator have come out recently, sort of asking openly whether arbitration still sort of fulfills the virtues it was meant to in terms of efficiency. And they used a good case study comparing two pretty similar commercial arbitrations where one, I think everyone was in and out in 18 months to 2 years. The arbitrator made a lot of proactive decisions to keep the parties moving things along and not letting things get bogged down in sort of what I call sort of procedural mechanisms. By contrast, a similarly sized damage and similar complexity commercial case dragged out to 5+ years, and they use that as an example to say, depending on which arbitrator you have and what type of process they allow to play out in that arbitration can have a very significant impact on not just the cost but the timing of getting through to a resolution.
What's the typical size of claim that sort of tends to attract arbitration as a solution?
It's really varied. So if you look at one end of the spectrum, the Americans love arbitration in consumer context.
Yep.
And so in a lot of your standard form consumer agreements, that will be the go-to form of dispute resolution where your consumer can bring a case against the can bring a case against the company, and that's meant to be resolved in a very quick arbitration. Many of those same contractual provisions have class action waivers in them in the US, which have found to be permissible on that side of the pond, to basically stop consumers having the types of recourse you'd have in Australia, where court action and class actions are much more common. So that's down one end of the what I call the small value arbitration claims, all the way up to your large value energy resources companies having multi-billion-dollar claims in arbitration that can span, I think in some cases, over a decade, where you're arguing over very large transactions or deals.
What's the most famous one?
I think the UCOS oil arbitration, because it obviously involved a number of different parties and had all the different procedural skirmishes down all the way down to who was actually writing the decision and was one of the arbitrator's associates, and got down into the minutiae of whose handwriting was on notes and writing styles.
What happened in that one? What was the issue or the dispute?
It was over big pipeline contracts, resources contracts.
With governments or?
The Russian government, yeah.
Yeah, so it was the Russian government and then the oil companies that were the opposing parties, were they?
Yeah.
Yeah. Wow. And how often is government involved in these? Are they regularly involved in? So
I mentioned the commercial arbitration piece, which is just party A, party B, and so obviously to the extent that the government is involved as a contracting party to any commercial arrangement, they can be a party. The other way in which states oftentimes get involved is through what we call treaty arbitration. So parties don't want to be, or investors for particular investments who don't want to be subject to the home ground advantage of the state where they're investing's courts, will oftentimes try to use what we call an investment treaty or a trade agreement to assert rights via arbitration that way. So you often see states as defendants in those types of what we call treaty arbitration cases.
Yeah. Sports is one that's quite common too, isn't it?
Yeah. So
I'm a big sports fan, let's be honest, but cricket, I think, was the one that always seemed to pop up in my head, or the Olympics or something.
Yeah, cricket and the Olympics, and it's sort of you've got your board of arbitrators who have subject matter expertise and who are available to sort of do expedited arbitrations for those types of disputes. Unlike there's sort of rarely an overlap in the funding space with those, because they're usually not about the money involved, but whether someone's met the requisite criteria to be chosen for a team or.
Yeah. And then the arbitrator. So what's their background? What does someone become? How does someone become an arbitrator?
Yeah, so my colleague Mark Mengen up in Singapore, he's an arbitrator. I think as of a couple of days ago, over 30 to 40 arbitrations where he has presided as the arbitrator.
Yep.
How you get into that space basically is by having worked for a significant amount of time as counsel and with other folk who have been arbitrators at the big shops that do that around the globe. So you've got Paris is a big centre for that, London's a big centre for that, New York and Washington DC also big centres where you have at many firms specialised arbitration practices that deal with that type of work day in, day out.
And can you just decide one day to be an arbitrator, or do you have to go through a selection process, or is it similar to becoming a barrister?
If you're going to be on the list of the institution, so I mentioned Akika before, you have to be able to show that you've either done a sufficient amount of practice in real life experience, or you've done a series of courses that allow you to be conferred a member or fellow status of that institution, and then they have a go-to list of arbitrators that can be used if you want to use that institution's rules to resolve a particular dispute.
When you look at the market for arbitration in Australia and compare it to the rest of the world, we're quite small, aren't we? In terms of we're in its infancy of its life cycle, in the sense that it's not as common compared to, say, other markets. Is that true, or is it just simply those other markets are just bigger, so they get more of them?
I think it is in its infancy. So what you'll see in Australia as well, we're a bit. It reminds me a lot of my time in New York working for a big law firm, where to be the lawyers growing up through that law firm had to be adept at both litigation and arbitration, because it was quite common for any given case to be in one or the other. Australia's very much like that, in that there is a lot of corporate trust in our domestic courts.
Yeah.
Where obviously here sitting in Sydney, New South Wales Supreme Court Commercial Division has a great reputation for resolving business-related disputes very quickly. Likewise, they have an arbitration list that can assure that any sort of satellite type disputes aren't used for gamesmanship or delay, and that the arbitrators are left to do what the contract says they should do and resolve disputes quickly.
Yeah.
So in Australia, we're growing up with the idea of where can arbitration be used to more efficiently resolve disputes, basically.
Yeah. How do you choose the arbitrator? Do you have to look at their experience or their area or specialty? How does it work?
Yeah, it's a very critical decision for any given case. Obviously, you're essentially choosing your judge in a way that you would never get the chance to do before a domestic court. And so, yeah, you look at every day. It seems like there's a new article about the use of AI and what you can find out via Google. Oftentimes, this sort of inside information about how different folk think and work as arbitrators can be absolute gold, in terms of just thinking through, how might someone view this claim, how are things likely to go. So real care is often given when you're proposing a list to the other side of which arbitrators you'd want to use on a case, what is the other side likely, who's the other side likely to agree to. So yeah, triangulating, are there publicly available materials that show how individuals have ruled in the past? Oftentimes that's very difficult in the context of arbitration, unlike, say, a court where the public judgments are part of the public record.
Yeah.
Yeah.
Yeah, because the judgment's all private, so that means only the parties that are part of the process get to see the reasoning for why that judgment was what it was.
That's right.
Any downside to arbitration?
Look, I mentioned this study before that the handful of folk have done about whether arbitration's continuing to meet the virtues it has historically sort of touted, which is timeliness, efficiencies, cost effectiveness. I think as those processes, if they're allowed to look like litigation or litigation light, the folks on the commercial end, I suspect, will increasingly start asking questions to be like, well, have we actually got any further ahead or done this any better than having gone down to the Supreme Court Commercial Division to have our dispute resolved?
So I'm not sure if this is possible to answer, but why would you choose arbitration over mediation?
Arbitration over mediation or litigation?
Or mediation over arbitration?
Well, so they're different things. So yes. The mediation is a consensual process. The mediator doesn't have any powers to sort of, or to form a binding resolution on anyone. So oftentimes you'll have retired judges in Australia performing the role of either arbitrator or mediator, and oftentimes they'll be the ones that come into the rooms over the course of a day of mediation and sort of reality check everyone to say, look, yep, I get what your advocacy positions are, but the reality here is there's X type of risk or this. Are you really going to?
Mediation's, would you say mediation's more commercial? It's a more commercial thing in the sense that, yes, it's not binding, agreed, but at the same time you're trying to get a resolution, just like arbitration is, just like a judgment is. But the reason why I was asking that question, which is probably a bit of an odd question to ask, but was that, like, if I'm a party, let's say I've got a claim and I'm the plaintiff, and my motivation is for a financial outcome because I'm a liquidator, right?
Yeah.
What would motivate me? And let's just say I've got some sort of legal claim in Russia let's say I'm the liquidator of these pipes, and they've gone into liquidation, and they've gone into liquidation because of the fact that there was a breakdown in the contract with the government, or the Russian government, or any government did something that caused the ultimate financial death of the company that I'm now liquidator. So I'm thinking that there's a claims there. Why would I? I'm trying to maximise return to the creditors, right? So there's the arbitration path, there's the mediation, there's the court path, I suppose, which probably includes the mediation.
Yep.
What are the things that I want to be thinking of in that sense to say, right, okay, how do I weigh up the differences and to come to, my motivation now. My motivation is to get a financial outcome.
Yeah.
So why would I choose arbitration over, say, mediation or commencing proceedings?
Yeah, so usually you'll find, I mentioned the sort of tiered dispute resolution provisions.
Yeah.
Certainly under both the federal court rules and the procedure rules in New South Wales and across Australia, it is standard to have mediation baked in as part of that process.
Yeah.
And the judges will push for that at certain juncture points to ensure that the parties have had every opportunity to make a commercial decision and hold their own fate in their own hands, rather than waiting for a judge to wade through reams of material and make a decision for them.
Yeah.
The same applies in arbitration. The arbitrators will often be looking for opportunities to nudge the parties towards mediation. So again, they can hold and be responsible for the commercial resolution of a dispute. And I guess to answer your question, it really comes down to the appetite of the parties to form their own views about what risks are involved in running a case through to the bitter end. Oftentimes the incentives on either side can oftentimes perversely sort of push for folks to dig into positions that may prolong litigation or arbitration.
That's an interesting point, because I've seen in many occasions when I'm in court for whatever process or action I'm taking, there's often narratives that the judge does to try and push you into mediation, and sometimes they come out directly and make an order. We're going to adjourn these proceedings, and you got to go off and do a mediation by the time we're back in court. Is that something you see in arbitration as well, where the arbitrator's going, okay, I think you talked about them suggesting mediation, but is there any things that you witness or comments made by the arbitrator to sort of push parties towards a mediated outcome, because they sort of already know where it's heading, and all they're doing is prolonging what will ultimately be the outcome? I certainly do feel sometimes when I'm in, sometimes in mediation too, but certainly in court proceedings, that the judge is very careful but very tactical about trying to guide certain parties, whether it's the plaintiff or the defendant, to do something. And you sort of get barristers are very cluey, and they pick up, little messages, indirect messages to say, oh, actually, you're in a pretty bad position here. Is that similar to what you see in arbitration, where they go to arbitrations, and sometimes you can see very clearly that a certain party is going to win this?
Yeah.
Does that happen within the arbitration process?
Look, certainly where the parties have committed under the contract to try and resolve under a tiered dispute resolution clause, non-adjudicative forms of dispute resolution, you'll see the arbitrator nudging parties to ensure that they've engaged in a robust version of those forms of dispute resolution, rather than just treating them like a tick box exercise.
Yep.
At the same time, the balancing there in sort of what in the phenomenon you're describing is arbitrators and or a judge sort of trying to nudge the parties into taking back control over proceedings so they can form their own commercial view, rather than waiting for a decision to be made for them. Yeah. In the arbitration context, often the arbitrators can be quite cautious about how far that sort of messaging is pushed, because they don't want sort of anything to boomerang back later in the dispute, suggesting that the arbitrator made their mind up already. Yeah. Especially given that we mentioned that there's not meant to be there's not an appellate mechanism for arbitral awards, but there are grounds to set aside and refuse recognition of awards. And so they want to make sure any process they oversee and or any award they produce does not cross over into those lines that then invite parties to engage in further skirmishes.
Well, Matt, thank you for today. It was great. The arbitration stuff for me was new and lots to learn there. But look, for those that are watching today, please reach out to Matt if you've got any legal requirements. He's at Lindsay Francis Mengen, and thank you for taking the time out today to speak on the podcast.
Thanks for having me, Simon. Really appreciate it.
Right. Thank you, everyone. See you next time. Bye-bye.
Thanks for tuning in to Cathro & Partners The Cut. We hope you've enjoyed today's episode. For more insights, please visit cathropartners.com.au or feel free to like our LinkedIn and other social pages.